Good morning. An example case in which a judicial officer was dealt with so many charges, and finally the division bench of the Karnataka High Court extraordinarily blessed that judicial officer and set aside the judge conviction punishment. Apart from that, they put an end that there should not be any further inquiry or movement in any of the delinquents. But Supreme Court intervened in a different way. This is AR 2023, Supreme Court 2005. Registrar General, High Court of Karnataka versus M. Narasimha Prasad. First you see the allegations against the judicial officer. He granted order of status quo and also ex parte temporary injunction against the state without following 80 class 2. That charge was proved. Then judicial have not examined the witnesses, issued non-bailable warrant, entertained criminal case, bail grant. These cases charges were not proved. Then the judicial had granted bail case involving offence under Karnataka Forest Act. Therefore, that charge was proved. Then again, without preparing text of the judgment, he simply passed a judgment. Actually prepared the judgment later only. So that charges were proved. His defense for that allegation was that his stenographer was not efficient. Then the judgment was pronounced on 9/10/2022, but actually the judgment was dictated on 11/10/2002. That was charge proved. He prepared a judgment but did not sign the judgment. That charge was also proved. Thereafter, judicial officer prepared a half-boiled judgment, not completed it. That charge is proved. Some portion of judgment alone was typed in the order sheet. Earlier other judgments were typed after 6 days. All this was correlated judgment. See, the thing is, then another most important allegation was he brought the properties for sale in public auction, criminal cases, and without mentioning and actioning the property, he sold to one Lingaraju, who is relation of typist attached to that chamber of the judge. That charges were also proved. The Honorable High Court has stated that without test correctness order of penalty, High Court record finding perhaps that the grand judge had first-hand information about the problem and the judiciary placed at the lower level. The opinion of the High Court, the impugned order that the act of omission commission attribute the respondent do not constitute grave misconduct is very, very curious. Then they set aside the order. Dismissing him from service itself is very atrocious. Such a finding is nothing but a veiled attack on the full court of the High Court. Therefore, finally, this is most important. The division bench further set aside, after setting aside the judgment, they say there shall not be any further inquiry against the delinquent and directed to treat in service with all monetary benefit with 8%. This they have set aside the judgment. This is what happening in the whole world. This is a test example of the case how judicial officers are dealt, because rightly or wrongly they have got some lobby within the judiciary. This is what happening. These allegations against this particular judicial officer in Karnataka is almost prevailing in almost in all cases. Even in my personal suit, the judgment 4-line was pronounced, the suit dismissed, but the judgment was only made ready after 2.5 months. Whatever it may be, I did not complain because I prepared appeal. One of the ground was that. And this actioning the properties, allowing the staff, because the staff, some of the staffs are hand and glove with the judicial officer in collecting the bribe, so many family courts in Chennai. And particularly few staff of the family courts are minting money, promising them to get an adjournment, what not, causing disappearance, the case bundle, etc. All this should be checked. I hope you understand my grievance, that you keep this judgment printed, keep a copy of print, and if any judge is acting, violating, but instead of lodging complaint, you send a copy of the judgment to that particular judge, at least let him mend, be alert or be careful. But some may not, like a dog which may not change his barking without reasons. Like that, the judges, even after allegations, departmental inquiry, they are dare to go with their modus operandi. I hope you understand why this. I will read it judgment again. AR 2023, Supreme Court 2005. Registrar General High Court of Karnataka versus M. Narasimha Prasad. And this Supreme Court judgment itself exhibits the division bench judges of Honorable Karnataka High Court behavior also in maintaining the sanctity of the judicial system. Despite these serious allegations, the court passes such an order. And I had several occasions to see that a judge who was trapped, dismissed from service, was awarded with compulsory retirement later on by division bench of our Honorable High Court, and thereafter he was considered to be one of the VVIP in appointing commissioners, arbitrator, what not. He is one of the agent for so many things. This is also happening here, and probably like what happened actually in law and order problem. If anybody arrested and detained under Gundas Act, after serving considerable period, he proudly entered the police station with some political influence and command the inspector to give illegal license to run any of the illegal activities because he languished in the police. Like that, some of the judges who are dismissed or removed or compulsory retired from service are authorized, permitted to enjoy the benefit because he is a fit person, sir, capable to do anything for the benefit of selective judges. This is what happening. This is what happening again and again. Now let us hope at least this commemorate day of opening up of a new parliament with Tamil Chola Sengol. Everybody says, what Sengol, what Sengol, what Sengol? And every High Court judge is having Sengol. Did you question that? Did you question that democratic system of Republican ideological balance? But simply because it is you want to oppose the Modi government, BJP government, the ideological sacrifice talent of RSS. You do whatever you want to do. We will do what to do, what not to do. People are with us. We are not bothered about the few people who are always want to disturb the orders. if you want to disturb the orders, at least you must have some proper order. But they do not have order. They think that they are the high elements to face anything. They can do anything. They can even overthrow the government. You can overthrow the governors. You can overthrow the president. You can overthrow the prime minister. Abusive. Anything you can do. You all will be deserved for punishment. We are following you all. Best wishes.